advised to appeal this matter for many reasons. Firstly, that it is not their matter. It is not their issue. They are not the ones who are objecting. And therefore, for them to be taking this issue and pursuing it, they'll be seen to have taken a position in relation to this particular matter when they're supposed to be a neutral party to the processes. In my opinion, the IEC must just focus on preparations for the elections and make sure that they're able to manage a smooth election going forward. It's a technical issue because you may recall that during the hearings, Advocate Dalimpofu did raise is to say that the person who sexually objected is not even here, is not even cited. So I'm not too sure how they're going to be able to deal with it, because a person who has objected to the Electoral Commission and not necessarily to Electoral Court. So I'm not too sure whether that particular person would then jump the Electoral Court when he had not actually even appeared in the Electoral Court and go to the Constitutional Court. So it's a completely different thing. I mean, the IEC has dealt with issues almost similar to this.
That is the view of Tselane, the former deputy chair of the IEC. Now he's with the Institute of Election Management Services. Please, let's hear the other side of this story. Zola Majavu is opposing what Tselane said. Please, let's take a listen. Don't forget to subscribe. Just listen.
With respect, I do not agree with that view. The IEC is a party to a matter in which a decision was given. It is, for whatever reason, aggrieved by that decision, and it is open to them to approach a higher court for further redress or clarity. It doesn't matter what we may personally feel about it, but they are legally entitled to taking the step that they did. So is President Zuma and the MK party, or even the original objector, to the extent that they were implicated by this court decision. So at the level of legal procedure, there is absolutely nothing wrong. And I do not agree with my brother Terry on this one. Look, firstly, let us look at the requirements for directly accessing the Constitutional Court and leave politics aside for a second. One, is there a legally justiciable matter that implicates on the Constitution? The answer is yes. Were they a party to this matter? Yes. Is this matter urgent? Yes. Is this matter sufficiently of a public interest nature, not what is interesting to the public? It is no doubt a matter of sufficient public interest. It also has to do with the interpretation that the IEC itself made of Section 47(1)(e). They interpreted in a particular manner. They stuck to their guns until someone took the matter to court. The Electoral Court said they got it wrong. So clearly there are different interpretations linked to this very important a clause in an Act of Parliament. So who is better positioned to give clarity to that except the courts themselves, and in particular the Apex Court? That is the reason why the matter is going to the Apex Court. There may be other underlying motives that people are reading into it, especially politicians. I stay clear from such. I just stick with the law and my understanding of the law. So I do not think that the IEC can be faulted for going to the Constitutional Court to seek clarity. The issue here is, and what I think is throwing all of us away or off the ball, is the fact that unfortunately in this instance, the Constitutional Court was the court of first and final instance, and it is its own order that was not complied with for whatever reason by President Zuma. And because of that, President Zuma did not have the further appeal rights that he would ordinarily have had if this matter had been processed in other lower courts in the normal course. So to the extent that there is a further proviso that says the sentence that may have been given is of a particular nature, that sentence will not take effect until the appeal processes had been finalized. But in this instance, after the Concord had spoken on the matter, where else could President Zuma have gone to exercise his appeal rights? So these are serious legal intricate matters that need to be resolved once and for all. And I think the IEC is correct. Whether they got it right or wrong in the first place, I'm one of those who believe that they bit more than what they could chew. They stepped outside of the province of their mandate. Maybe I'm wrong, but maybe they are right. But it doesn't matter. The court of final instance, in this instance, is the apex court. The Concord is the one that will pronounce definitively on the matter. And then everybody knows either the MK party is right or the IEC is wrong. But you need legal certainty, and you can't get it from legal commentary or the Twitterati. It must be pronounced upon by a court of law.
Two legal minds, Tselane and advocate Zola Majavu. Which one do you side with? Do you think Tselane is right? IEC was not supposed to appeal the verdict that Zuma won against the IEC? Or are you going with Zola Majavu, that the IEC did the right thing so we can rest this case once and for all? Please leave your comment down below. Don't forget to like. If you haven't subscribed to this channel, please just click that subscribe button and share this video. Thank you for watching. Check you in the next video. Cheers.